page number 33 and 34. Hooghly, legal dictation, get ready, start. This appeal by special leave is directed against the impugned judgment and decree dated 12.10.2001 passed by the High Court of Jharkhand at Ranchi in second appeal number 88/2000, whereby the High Court dismissed the appeal filed by the board by confirming the concurrent findings of the courts below. Brief facts in nutshell. For proper adjudication of the dispute involved in the present appeal are: the plaintiff has filed a suit for permanent injunction alleging that suit scheduled property originally belongs to Raja Singh. Later, the property was purchased by Kumar Singh, YD, registered sale deed number 3201, dated 4/12/1989. He in turn sold the property to the plaintiff, YD, registered sale deed dated 8/8/19, for a consideration of rupees 12,000, and since then he is in peaceful possession and enjoyment of the property by constructing a residential building in the land. While that being so, the defendant board has issued notice dated 4/1/1992 asking the plaintiff to quit and give vacant possession of the suit land, and threatened the plaintiff to dispossess from the suit land without any right and title over the same. Hence, the plaintiff has come up with the present suit to protect his possession. The defendant has filed the written statement contending that the plaintiff vendor has no legal right and title over the suit scheduled property, and the sale deed executed by the vendor will not confer any right or title to the plaintiff. Further, the suit scheduled property along with other properties was acquired by the defendants by way of land acquisition proceedings in the year 1965, and the possession was handed over to them as such. Except the defendant, no one else has right or title over the property. The defendant has taken several other grounds with regard to maintainability of the suit on the ground of misjoinder of proper and necessary parties to the suit, on the ground of limitation under section 92 of the BSHB Act and rules, as no prior notice was issued before instituting the suit. Also, under section 62 of the CNT Act, it is the case of the defendant that the present suit is not maintainable without seeking the relief of declaration of title. The suit scheme property was recorded in the revenue records in the name of the defendant without seeking right, title, possession, and correction of entries in record of right. plaintiff cannot maintain the suit for injunction and hence sought for dismissal of the suit. The trial court has decreed the suit, holding that suit is not barred under any of the provisions of the BSHB Act, CNT Act, and the Limitation Act. The court took note of exercise B letter of giving possession to the defendant has come to the conclusion that the evidence on record does not establish that the land acquisition proceedings have attained finally with regard to maintainability of a suit for injunction. Court gave a finding that as a plaintiff is able to prove his possession by oral and documentary evidence, he can maintain a simpliciter suit for injunction without seeking the relief of declaration. A conjoint regarding of sections 1351 and 1382 would indicate that the usual practice in any trial, be it civil or criminal, is for the examination in chief of a witness to be carried out first, followed by the cross-examination, if so desired by the adverse party, and then re-examination, if so desired by the party calling the witness. Section 231 of the CRPC indicates that the judge, in giving the declaration to defer cross-examination of a witness until any other witness or witnesses have been examined. Section 231 is set out herein. Section 242 under bracket 3 is analogous to section 251A within bracket 7 of the repealed Code of Criminal Procedure 1989, and it identically worded. Section 251A was inserted within the Code of Criminal Procedure within bracket Amendment Act 1955 in the erstwhile Code of Criminal Procedure 1898. The statement of objects and reasons of the Code of Criminal Procedure within bracket Amendment Act 1955 suggests inter alia that changes were introduced to simplify the procedure in written cases, to ensure speedy disposal of criminal judicial business, to minimize inconvenience caused to witness, and to ensure that adjustments are not allowed without the examination of witnesses present in court except for an unavoidable cause. What follows from the discussion is that the norm in any criminal trial is for the examination in chief of witnesses to be carried out first, followed by cross-examination and re-examination if required, in accordance with Section 138 of the Indian Evidence Act 1872, Section 231 within bracket 2 of the CRPC, however, confers a discretion on the judge to defer the cross-examination of any witness until any other witness or witnesses have been examined, or recall any witness for further cross-examination in appropriate cases. Judicial discretion has to be exercised in consonance with the statutory framework and context, while being aware of reasonably foreseeable consequences. Stop.